All right, we are now recording. We're in the final minute before our session begins, and now we're here. I'm going to put on my reading glasses. Welcome to this session on misclassification. We have an exceptional group of panelists and a discussant. This is being recorded. For those of you who are attending, we have scheduled a period of time toward the end, after the presentations, when there'll be an opportunity for Q&A. So I ask that you use the chat function to post any questions you may have. As chair of the session, I will try to keep track of those and present them to the panelists when we get to that time. All right, now I'm going to introduce the panelists. They are Mark Ehrlich, who's been a Wertheim Fellow at Harvard Law School's Labor and Work-Life Program since retiring as Executive Secretary Treasurer of the New England Regional Council of Carpenters. He's an author of 2 books, With Our Hands, The Story of Carpenters in Massachusetts, and Labor at the Ballot Box, both with Temple University Press, and lots of journals, academic journals, articles. David Seligman is an attorney and the executive director at Toward Justice, a nonprofit law firm based in Denver, Colorado that uses impact litigation, policy advocacy, and collaboration with workers and workers' organizations to advance economic justice and build worker power. Ali Hinga-Nevitt is an assistant attorney general at the Office of the Attorney General for the District of Columbia. She serves in the Public Advocacy Division and focuses on workers' rights. Ali is co-chair of the Labor Trafficking Subcommittee on the Washington, D.C. Human Trafficking Task Force. Our Matthew Capice is our discussant, and he is a representative of the General President of the United Brotherhood of Carpenters and Joiners of America. He's an attorney and a specialist in matters involving employment tax fraud, workers' compensation insurance premium fraud, and wage theft in the construction industry, and has been doing that for over 30 years. I'm William Canick. I'm a professor emeritus of sociology at Middle Tennessee State University. My research interests include employment and labor law, and recently employee misclassification and apprenticeships. I am past president of the Tennessee Employment Relations Research Association, and currently I'm chair of LARA's National Chapter Advisory Committee. That said, our order of panelist presentation will be Matt, David, Ali, and then Mark, David, Ali, and then Matt. Ali and David will have a little exchange in the middle, so don't be surprised by that. Thank you all. And Mark, I turn this over to you.
Thanks, Bill. I'm going to share screen. Hold on. Okay. Okay, does that, I hope that works. Everybody see it?
It looks good.
Okay, very good. So my name is Mark Ehrlich, as Bill said, and I, as the only non-lawyer on the panel, my job will be to basically try to tell a story about how we got to the point that we are in the construction industry, and why it matters, why the concept of joint employment matters. So I'm going to quickly go through really the changes that have happened over the last half century in the industry, and cover topics, and those changes include a sustained corporate attack on building trades unions, the realignment of owner and employer relations, political, legislative, and regulatory attacks, as well as the growth of misclassification, payroll fraud, and the emergence of the underground economy, and the introduction of immigration as an issue and resulting in changing workforce demographics. But basically, if you look at the, from 30,000 feet, the result over the last 50 years has been a decline in union density and reduced standards in the industry. So let me look at some of these more specifically. When I talk about the corporate attack, I'm talking really going back to the late 60s, an inflationary period in construction. Prices were rising, building trades unions agreements were rising. There was labor shortages because a lot of the young men who might have been in the industry were in Vietnam. and the large owners who were engaged in capital expenditures were alarmed by the rising cost of construction and formed the Construction Users Anti-Inflation Roundtable in 1969, which became renamed to what is more familiarly known today as the Business Roundtable. The Roundtable, over the course of the 70s, put together a series of booklets called More Construction for the Money, which outlined a strategy to diminish union power and reassert the role of owners in the industry. And the result was that they argued that the general contractor's loyalty was to his regular partners, that is subcontractors and even unions, and not to the owner, because the contractors would move from one owner to another as projects developed. So there was a shift from general contracting to construction management, and where the construction manager worked for a fee, did not provide a lump sum bid, therefore shed risk for a bad estimate and shed responsibility for direct hires. So that you see from the 30 years following 67 and 97, that the direct construction worker employment went from 35 to 24% of the labor force for the GCs, and whereas the specialty subs increased from 48 to 63. At the same time, there was a whole sort of process of legalizing misclassification, a combination of the increased subcontracting from construction management, Section 530 of the 1978 Revenue Act, which essentially grandfathered and provided a safe harbor for misclassification practices, took the IRS out of the enforcement game, and the 1986 Immigration Reform Act, which penalized employers from knowingly hiring then it was termed illegal aliens as employees. So this notion was, well, if people weren't employees, you wouldn't have a problem. And there was a cottage industry that developed of lawyers, accountants, and consultants who went around the country teaching contractors how to take their payroll, which on Friday everybody was an employee, to Monday to where everybody's an independent contractor, thereby saving somewhere around 30% in tax and insurance obligations. And there was a creation of contracts to paper this reclassification to the point where courts recognized that paper as answering the question of whether someone was an employee or misclassification, as opposed to whether they are what their tasks were based on. They simply, the existence of a contract, as this case, tipped the scale decidedly in favor of the conclusion that this gentleman was an independent contractor. So you had a traditional model where you had the owner hiring a general contractor. The general contractor had direct hires who were employees, and they were typically the basic trades, and then they would subcontract out the mechanical trades and some of the other trades, but those subcontractors would have employees on their workforce. So everybody on a construction site, certainly when I started in the industry, was an employee. And the newer model was that the owner would hire a construction manager who would still have some direct hires, typically the superintendents, maybe some laborers to do cleanup and a handful of basic trades, but pretty much all of the work was done now by subcontractors representing all of the trades, basic and mechanical. And those subcontractors had some employees, some independent contractors, and also subcontracted out to labor brokers who would often pay their folks in cash, particularly as the immigrant workforce increased in the industry. So by 2000, you had an industry textbook which said that the era in which general contractors perform significant amounts of work where their own forces is largely over. And the reduction of direct hires of employees correlated with the use of independent contractors, and the growth of the undocumented immigrant workforce, which was 15% of the national construction workforce by 2014, correlated with the rise of labor brokers and cash compensation. So this whole new business model rested on the notion of joint employment. That is to say that the construction managers relied on multi-tier subcontracting system to get the job done. The responsibility for providing labor, for performing the work, and the subsequent potential of wage violations were really now on the shoulders of the lower tier subcontractors and the labor brokers. And the construction managers made sure that they were insulated from any potential legal liability by including in their contracts with their prime subcontractors that called for adherence to all applicable federal and state laws, thereby removing themselves from any potential liability. Now, Peter Phillips, an economist at the University of Utah, has done some interesting couple of graphs that show that when you create this system of the lower tier contractors only handling labor and not the upstream contractors who are doing both materials and labors, and therefore allowing markups on both labor and materials. Whereas the labor brokers can only mark up labor, that created a situation in which they were under price pressure because their profit margin opportunity was reduced, and were therefore incentivized in many ways to commit labor violations. One story I will tell is when I was the head of the New England Carpenters, we filed for an NLRB election with National Carpentry, which was at the time the largest non-union wood frame carpentry contractor in New England. Dozens of jobs, hundreds of wood frame carpenters, and in response to our filing, the owner responded that he never employed any employees. The board, the regional office concluded that the fact that the employer may have exercised supervisory authority over the employees, or paid the employees, or participated in their hiring, or set their wage rates did not provide conclusive evidence that it was the employer alone who employed them. The owner told the board that the real employers were a group of 14 subcontractors, and when the board sent subpoenas to the addresses, all were returned undeliverable. So what is the result? Which most recent effective report says that between 12 and 20% of construction workforce is either misclassified or paid off the books, representing somewhere from 1.3 to 2.2 million workers. The reason the gap is so large in these numbers is because obviously if you paid off the books, it's unrecorded and unreported and very difficult to measure. And you have a bifurcated industry in the big cities, in the Northeast, in the West Coast, in the Midwest, got still strong union density, good wages, good benefits, good working conditions. And then in the South, Southwest, Rocky Mountain states, and most rural areas and the residential markets, you have wage theft, poor safety issues, and a very different kind of industry where the pathway to the middle class, which had been the historical, is sufficiently reduced. So quickly, Ali and David are going to talk about the legal issues. I will just mention a couple, that there are some states with joint and several liability that create upstream liability. In May, for example, the California Labor Commissioner's Office issued 600,000 in citations for unpaid wages and penalties to Universal Structural Building Corp. And also the general contractor was held jointly and severally responsible. Julie Sue, who was the labor commissioner at the time and who is now waiting to be confirmed as Deputy Secretary of Labor, was quoted saying the up-the-chain general contractors are now responsible for wage theft committed by the subcontractors on all construction projects in the state. And the municipal example in Somerville, Mass, 2020 wage theft ordinance has all the conventional language, prevailing wage, no independent contractors, workers' comp insurance, et cetera, but also sign in and sign out logs as a way of measuring this invisible workforce. And the penalties include cessation of work, which is the most, the biggest burden you can put on a job is to have it stopped because the schedule is critical, and it makes all generals equally liable for violations of subcontractors. So that is my presentation, and I think that Ali and David will move forward on explaining what else is going on from a legal point of view. Thank you.
Excellent, Mark, and right on time. Our next panelist is David Seligman, sorry, and I'll turn it over to you, David.
Great. Thanks so much. And folks can see my screen now, right?
Yes.
You
haven't put it on full screen yet.
I have not put it on. I'm sorry. I'm gonna have to reshare. Notwithstanding all of the practicing, I managed to somehow screw that up. So, well, let me say, while we're waiting, Mark, I should point out, I really appreciate, first of all, I think every panel should have non-lawyers, as many non-lawyers as possible presenting, but especially panels about joint employment, because the concept of joint employment is often much more intuitive to non-lawyers than it is to lawyers, and lawyers have been part of the problem here, right? Like all of these structures that you've described, subcontracting, franchising, staffing agencies. These are creatures of contract and creatures of lawyers, right? Who will then, when joint employment principles are sought to be applied to their clients, will point to these sort of often legal fictions as a reason not to apply the sort of common sense policy that would make a ton of sense to non-lawyers. So I think that is a big caveat to this entire presentation. I'm going to talk briefly before I turn it over to Ali to what's happening with respect to the FLISA's joint employment standard under federal law and where we stand now with the DOL and litigation that's been ongoing. I'm going to cover this in far too brief of a period to do it full justice. So backing up to 2016, the Obama Department of Labor, with David Weil as the Wage and Hour Administrator, issues a set of really important administrative interpretations. One of the most interesting and most important from my perspective being the one on joint employment. There's a lot going on in that administrative interpretation. I think most important for our purposes is it highlights that the tremendously broad scope of the test for the employer test or the joint employer test under the FLISA, a test that looks not just at the definition of employer in 203D of the FLISA, but also at the broad definition of employ with a suffer or permit test. It also points to the sort of historical context underlying this broad definition and the goal of ensuring that those who were profiting off of another, for example, off of child labor, that they were held to account for violations. So that's the context that supported a test for employ that extended even beyond the tests in the NLRA and in OSHA. There's also some really interesting discussions in that AI on the differences between vertical joint employment, when you have an employer employing workers through an intermediary, and horizontal joint employment, which often comes up when an employee, for example, works for two employers who are sufficiently intertwined that for example, you could say that hours in a single week worked for one employer should be added together with hours worked for another employer for the purposes of determining whether the employee has worked overtime. That's all very interesting, and there was sort of an interesting conversation that related to those issues initiated by a subsequent Fourth Circuit case called Salinas. And I think that in a different world, that could be a presentation unto itself. But the Trump administration issuing a 2020 rulemaking sort of erased much of the sort of nuance here and substantially undermined the sort of foundations of the test for the test of the employer test set out in the AI. Really critically, the 2020 rulemaking focused exclusively on the definition of employer in 3D of the statute, which does define employer, but uses the concept of employment, and therefore, from my perspective and from the perspective of litigants in courts following the DOL rule, should also capture the suffer or permit test from 203G. The Trump rule focused on something like a common law test, right, of the whether the employer controlled the employee. I'll say it even goes beyond the common law test because it looks at actual control, not just the authority to control. And really importantly, the Trump rule appeared to suggest that employers who relied on franchising models, for example, would be able to say that those models necessitate some types of quality control or brand control, and that those types of controls wouldn't go into the joint employer analysis, which I think is especially problematic for reasons we'll discuss later. we'll hear more about this, but a group of states sued the Department of Labor in the Southern District of New York, and the court ruled that the rule was ultra vires, that it was not grounded in the statute, and that the administration had not done a sufficiently good job of explaining why it had departed from the common sense positions taken in the AI. So the rule was vacated by the Southern District of New York, and then while that decision was on appeal, the DOL in 2021, after the Biden administration came in, vacated the Trump rule. So now we have a vacated Trump, or they proposed a rule, sorry, apologies. They issued a notice of proposed rulemaking to vacate the Trump rule without and not to replace it with anything. Meanwhile, the Second Circuit has denied a request to hold an appeal from the Southern District of New York case in abeyance. So right now we have comments in on the Biden administration's proposed rule, and we've got the Second Circuit, which will be hearing an appeal from the Southern District case, with industry having intervened to defend the Trump rule. I'll kick it over to Ali. Oh.
Thanks, David. I will pull up my presentation. I think, just to comment on, can you all see my screen? Great. There you go. Just to follow up on what David was saying, our office, I work for the DC Attorney General's office, and our office was part of that litigation, is currently part of that litigation. And what really struck me about that rule during the Trump administration was it really failed to meaningfully consider the extensive harm it would have to workers, because we all know that this increased fissuring in the workplace creates lower wages, more wage theft, and less job security. And what we see is that, especially for immigrants and people of color who are disproportionately in these jobs, in these non-standard work arrangements, and are making lower wages, they were disproportionately impacted, or would have been, by this rule. And so that's an important reason for us, and why we thought that we should challenge the rule, just the practical impacts of what it would have done if it had gone into effect. But we are still litigating that, as David said. So today I'm going to talk about illegal worker misclassification, specifically focused in the District of Columbia construction industry. Everything I say today is my own opinion. It's not the official stance of the District of Columbia. So DC has great, strong wage laws. We actually have joint and several liability, and this has been vital for our enforcement efforts. I pulled some of the language to put it up here so you could see it, that a subcontractor, including any intermediate subcontractor, and the general contractor may be jointly and severally liable for a subcontractor employee's violations of our wage law. And thankfully, the DC Council enacted this legislation, and it led to the creation of a workers' rights unit in our office, the DC AG's office. And joint and several liability really allows for the collection of back wages if one of the employers is insolvent, or if one of the people down the line has failed to properly classify their workers or abide by our district wage laws. It really helps to go all the way up the chain. Another thing that's been really helpful for our workplace enforcement is the district's Workplace Fraud Act, which only applies to the construction industry. And it's codified the ABC test just in the construction industry. So I think that most of you are probably familiar with the ABC test. It's been in the news a lot coming out of California with Dynamics decision in 85 and Prop 22. We have that, but it's specific to the construction industry. And I'll just briefly go through the 3 ABC factors for those of you who may not be familiar. A worker is presumed to be an employee unless the employer can show all 3 of the following conditions: that the worker who performs the work is free from control and direction over the performance of services, that the worker is customarily engaged in an independently established trade or profession, and that the work is outside the usual course of business of the employer for whom the work is performed. So this is a pretty high bar for, especially for construction companies. And in the district, we have really high penalties for violations of this law. A civil penalty in the district for misclassifying a worker is not less than $1,000 and not more than $5,000. So, and each employee who's not properly classified is a separate violation. So you can imagine how, if this is a bigger construction project, and let's say you have 100 misclassified workers, that can add up. You know, each worker, if they're a $5,000 penalty, you're looking at $500,000 just in penalties. And our law also, you know, requires companies that are found to be in violation to give restitution to the workers, treble liquidated damages, and otherwise come into compliance with all applicable labor laws. So what our office has done is we really wanted to understand at the beginning, the creation of our workers' rights unit, how big of a problem was misclassification specifically in the construction industry. And what we found was that it was a rampant problem. And we commissioned a report from two labor economists, Dr. Dale Bellman and Dr. Aaron Sojourner, on the economic impacts of worker misclassification in the district. And the researchers found that by misclassifying workers, a company could illegally reduce its labor costs by at least 16.7%, but as high as 48%. So you can imagine the incentive to engage in this illegal behavior is very real. And it makes it all the more important for prosecutors like RAG's office to hold companies accountable when they are misclassifying workers. And our Attorney General, Carl Racine, also provided Congress with testimony on the findings of this report. And, you know, it really goes into detail on the harms of worker misclassification. I mean, just starting off with the fact that when someone's an independent contractor, they're responsible for footing the entire tax bill. So instead of normally you would share, you know, Medicare taxes and Social Security taxes with the employer would pay their equal share. When a worker's misclassified, they're on the hook for paying all of those taxes. And so, you know, that's just one of the harms of reducing take-home pay for misclassified workers. But it also puts law-abiding companies at a severe disadvantage, because especially in the construction industry, when it's a bidding process, if you're a law-abiding company and you are following the laws and your labor costs are higher, you might miss out on the bid to an illegally operating company who is undercutting their costs and gaining the bid at the expense and on the backs of workers who are being misclassified. So what our office has done is we have taken a number of enforcement actions in the construction industry and used these strong wage laws, the joint civil liability and the ABC test, to go after construction companies that are violating our laws. And this slide refers to one against Power Design, who was a major electrical contractor headquartered in Florida, but the company had worked at a number of large construction sites in the district. And in 2008, our office sued Power Design and a number of their subcontractors, alleging that they had misclassified over 500 workers throughout their projects. We also allege that Power Design and its labor brokers failed to pay minimum wage and overtime and sick leave, and failed to pay district payroll taxes with unemployment insurance. And this eventually resolved in a settlement where Power Design was ordered to pay, or agreed to pay, $800,000 in back wages to workers. They were agreed to pay $1.8 million to the district in penalties, and was based on those penalties that are codified in our law, the $1,000 to $5,000 I was speaking about earlier. They paid $50,000 to support apprenticeships, job trainings, and workforce development programs. And there was also prospective injunctive relief, where we implemented measures to ensure compliance with district law in the future. And for the years 2020 and 2021, they need to produce, need to produce what subcontractors are using on the jobs and their policies and procedures to make sure they're coming into compliance with district law. And finally, this slide refers to 2 other wage theft enforcements that we did. One of which was with a construction company who was required to pay $280,000 for allegedly misclassifying workers as independent contractors and depriving them of overtime and sick leave. And the way we're able to do this and come to settlements, many times before we even file a complaint, is that in our DC law, we have pre-suit subpoena power. We have pre-suit power to inspect documents, to take depositions. And many times when we're working with companies in the construction industry, we can work with them and help them understand and come to a pretty good estimate of what the wage theft violations have been. And so many times we come to a settlement in a wage theft case before even filing a complaint. So this is contact information. I've also put up the contact information for our new chief. We recently created a new workers' rights and anti-fraud section. Our office is really prioritizing, making sure that we are advancing and defending workplace protections, particularly in the construction industry. So with that, I think I will ping pong it back to David.
Thank you very much, David. It's your time. You have 4.5 minutes left to use later, Ali, if you wish. David, it's yours.
Wonderful. Thanks very much. And I took up more time on my first bit than I'd intended. So unfortunately, I'm going to have to rush through some of these first slides. But I was going to, as a little bit of a teaser, I was going to talk a little bit more about the importance of more state action in this space, whether not only by extending joint employer protections legislatively or through state level regulations, but also through enforcement, like some of the cases that Ali has highlighted in the District of Columbia. First of all, I think that as we see an increasing crackdown on misclassification, we're going to see increasing fissuring. That's actually what we saw in California after the passage of AB 5, when staffing agencies targeted California and expanded their footprint in the state. I'll also say, and this is a bit of a teaser for a presentation that I'm part of immediately following this one with Kate Bond, who I believe is on this call as well, about the relationship between antitrust and anti-monopoly concerns and the labor market. We increasingly see companies across a Fisher workplace restrain the abilities of workers to move between companies within the Fisher workplace. So the antitrust litigation against franchisees who had no hire provisions in their contracts with franchisors is a good example. And I think that the joint employment laws are actually a good way. Expansive joint employment is a good way to resolve some of these issues, often a better fit than the antitrust laws. There's highlighting some of the different approaches that states have taken. California, and this refers back also to some of Mark's presentation. California has an especially broad approach, defining, requiring client employers to bear responsibility for wage and hour violations. This would apply in circumstances far outside of construction. So the use of staffing agencies and intermediaries. In other contexts. Virginia and other states like DC have passed construction industry specific law, and I understand that the New York legislature just passed a law waiting for the governor's signature that would include in the construction industry in particular general contractor liability. A bit of context in Colorado. I began working on these issues in Colorado when we represented a group of drywall workers that were able to recover $1 million in a settlement with a drywall subcontractor that had used a labor broker to directly employ its employees. Colorado, before that case from a couple of years ago, in the construction industry, the concept of joint employment was entirely foreign. There was no case law on it at all, and contractors and subcontractors acted acted as though their subcontracting relationships immunize them necessarily because of the practices within the construction industry, sort of construction industry law and practices, as opposed to how wage and hour laws work. They assumed that those practices immunized them. That was not the case in our litigation, and then we were actually able, through a bipartisan effort, to pass an expanded version of the employer of the test for employer and tie it to the Fair Labor Standards Act. We did that during the Obama administration, and as a consequence of the Biden administration's, the Trump administration's proposed rule, our Department of Labor looked to promulgate its own rules, hewing Colorado's test to the administrative interpretation from the Obama administration. And industry, this is in the spring of 2020, industry put a tremendous amount of pressure on the governor, and that rulemaking has stalled. So we're left with no rule right now in Colorado, but a statutory provision tying our test to the FLISA definition. I'll turn it over, I believe, to Matt.
Yeah, thank you very much, David. These three presentations were really clearly presented, clearly stated, and very useful. Thank you so much. I now turn to our discussant, Matt Capiz.
Thank you, Bill. And here we go with the sharing screen stuff. Okay, I think you can see that. Well, excuse me. So as you've heard, a lot of this discussion has been focusing in on the construction industry, and that's because the structure of the construction industry, with all the fissuring, really does dovetail and enables wage theft and other violations of workplace protection. But you should take this discussion also as a warning or a predictor of what can happen in other industries as well that are currently as fissured as the construction industry, or that could become as fissured as the construction industry. I'm going to spend a little bit of time on this slide. This slide can serve as a summary of a lot of what you've heard. Hopefully you can see my cursor moving around. So what Mark was talking about is when he started in the construction industry, you had general contractors that hired and contracted to specialty subcontractors that had employees. Then starting in the 80s, we started having construction managers who didn't really have a direct contracting relationship or any loyalties to the specialty subcontractors. The specialty subcontractors would contract with the owners, but the specialty subcontractors would still have employees. Now we have put into place by the industry labor brokers that stand between all of these folks and the employees. And as Mark explained, we find these labor brokers violating employment and tax laws. And as Ali said, that allows them to reduce their labor costs and help the specialty subcontractors underbid law-abiding contractors. Now, this raises a lot of problems for law enforcement. When law enforcement steps in, or a litigator like David representing a worker who is employed by a labor broker who hasn't been paid overtime, the focus is on the labor broker. And one of the problems has been is that these labor brokers are the low-hanging fruit, and they're used by the specialty subcontractors to shield themselves against liability for the unpaid wages to the employees. So if there's a breakdown in a joint employer legal theory, making this, that would make the specialty subcontractors or even some of these folks to the left side liable for unpaid wages, let's say. If that breaks down, these guys, the labor brokers, are easily replaced. They're a dime a dozen. And so this model stays in place in markets, and the law-abiding contractors just can't compete against it. And they get marginalized into narrower and narrower sections of the market. We, in the Carpenters Union, it's known to us that there are whole states, let's say Florida, Utah, I would put Colorado in there, Texas, Oklahoma, Georgia, where this type of model dominates in the construction industry. We need to talk about some myths. There's a myth. Well, whenever I raise this subject with, let's say, legislators, the immediate thing pops into their head is we're talking about small businesses and small construction jobs, but nothing could be further from the truth. Take a look at this check on the right side of your screen. This is a paycheck that we were given by a worker on a job site. As you can see, there's no, this guy didn't get a stub. There's no deductions for any taxes. And if you see here, he worked to build an IRS building in Georgia. And this is, the IRS building isn't a residential building. It's a government building. It's not small. So this problem has reached out of the residential industry and firmly into the commercial construction industry and even into the industrial market. Another myth is that this is unintentional behavior, because there are many different definitions of employment and employer, and so contractors are just confused, and they can't tell the difference between an employee and an independent contractor, and they're just making a mistake. While we're not going to say that doesn't happen, that certainly does happen. What we see a lot in the industry is intentional conduct by these actors. For instance, there's a case that we're looking at in New York where a contractor is running his payroll through 18 different shell companies. What kind of business is going to have 18 companies paying its workforce? There's a contractor, a set of 3 contractors in Tennessee that keep on using a labor broker who's been caught at least 5 times by state Bureau of Workers' Comp and twice by the USDOL. And none of those entities have ever applied a joint employer theory to create liability to the 3 contractors that continuously use this labor broker, who continuously changes the name of his company. Is that a legitimate business practice? And that's very intentional. Oops. Let me get back to, oh, I lost the screen sharing. Stop. Sorry about that. Okay, we're back. Okay, as David's presentation pointed out, we're in a position where there may be some ping pong happening on the federal level, where we've seen the joint employer theory starting to bounce back and forth between administrations from something that's very narrow to something that is more expansive and more that follows Supreme Court and other precedents. And we see states, there's a current trend in states, a few states, but it's a growing number of states. They're adopting definitions of employment that favor independent contractor status, that are creating this independent contractor status mainly through adhesion contracts. Now, this doesn't mean that federal and state law don't have an application. If you put yourself in Ali's shoes, who has this joint and several liability law in DC, they can hold contractors liable for wage theft without having to show joint employer, without having going through the steps of showing a joint employer theory. But what about the contractors coming to DC out of Georgia, which is a safe haven state, which has very lax enforcement? So this is why for instance, we would need to see robust use of a joint employer theory in the country, in Georgia. So the people coming to DC and these other states with the joint and several liability laws, give them a break. And one of the things that we hope happens, my organization hopes happens with the increased adoption of these joint, several and individual and several liability statutes, is to create some incentive on the general contractor community to break apart that flow chart of fraud and stop using subcontractors and labor brokers that are going to break the law and not pay workers, and have taxes not paid. So if we create that incentive, we could bring some stability back to the labor market in the construction industry. Thank you, Bill.
Thank you, Matt. Very well done. Again, thank you for all of these excellent slides, very informative and present a clear picture. We now have, let's say, 13 minutes for a Q&A. We have one question that's been posted in the chat room. What I'm going to do is present that question to the panelists and our discussant, and then I'm going to give an opportunity for the panelists to ask some questions of each other. Since the question is, what can be done with labor brokers misclassifying their employees in a way to manipulate workers' compensation rates, such as classifying construction workers as clerical employees? We know from a variety of cases that this happens to avoid higher rates. Anyone want to answer that question?
I'll dive into that. Yeah, this one really gets me going with the workers' comp insurance carriers. Mm-hmm. The workers' comp industry has adopted practices that, to put it bluntly, enable fraud in the industry. If you've ever seen a workers' compensation certificate of insurance, there is usually no indication of the type of work performed. So workers' comp insurance certificate of insurance for a construction company with high-rise iron workers will look the same as one for a company that has clerical employees. And there will be no mention in that certificate of insurance that shows the range of payroll. So you have lots of companies, they'll get a minimum workers' comp policy and actually have hundreds of workers on their payroll, but they'll only say to their insurance broker that they have a small amount. And those certificates of insurance, which are given to upper tier contractors, will not give a clue of the payroll being hidden. So what has to happen? Well, a lot has to happen within the insurance industry, and that will include modifying their certificates of insurance, make sure that they show the type of work being performed, a range of payroll, for instance. You need insurance companies to start monitoring the number of certificates of insurance that are sent out by their insurance brokers for their insureds. And we need more robust enforcement on the state level to hold the people who are doing this to task with criminal and civil liability, as we're trying to do as Bill will also tell you, as what's happening right now in Tennessee.
Yes.
Well, just two quick comments on that. My experience during the years I was running the New England organization was that I would meet with insurance carriers, and they were fully aware that there was a fraud going on, and they would have audits, internal audits, that would show that. But they were reluctant to actually crack down because they felt that what would happen is that one of their other competitors would simply pick up the policy and get the premiums that they were then losing, and not really care about whether the classifications were accurate or not. So that's item number one. Number two is that to the degree that the industry has moved towards a cash compensation economy, it all becomes irrelevant. There's no purchase of any kind of workers' comp insurance. And so there's no fraud. You've just eliminated it by turning everything into cash.
Yeah, Mark just said something that queued me up on another point. With cash pay, that cash pay is frequently gotten from money service businesses, commonly known as check cashing stores. And in some instances, we find that those check cashing stores are used by drug cartels and organized crime to launder their money. So this construction industry, fissuring, labor broker, shell company, check cashing store schemes that we see, especially in Florida, but even up into New York, is a way for organized crime to launder their money. It's being used in that fashion.
And I'll just say in DC to Mark and Matt's point, that what we're seeing when we're subpoenaing labor brokers is that they're paying in cash, they're paying just personal checks, and they're not paying into the workers' compensation system at all. And that's where the joint and several liability really helps us, because we can go after the contractors up the chain to pay for those lost rates.
All right. Well, a great question and some great answers. I'm going to turn to our panelists now, because I know that they have prepared in advance some questions for each other, and we reviewed those. So would any of you have like to take the lead and present a question to one of your fellow panelists?
Yeah, I have, I'll ask David a question. Dave, you talked about the amendment to Colorado law that your employer definition, your employment definitions were mirrored the Fair Labor Standards Act. If this Trump joint employer rule had gone forward, how would that have impacted the potential interpretation of your amended law, since you were borrowing terms from Fair Labor Standards Act?
Good question, Matt. The Colorado legislature was careful to tie Colorado law to the statute, and not to interpretations given to the statute, sort of in anticipation of the possibility that the Trump administration might do some mischief to sort of standard, generally accepted joint employment tests. I'll say something that I do think if advocates and lawmakers in Colorado were to do it over again, something that we might do differently is that we incorporated the definition of employer from 203D with the expectation that, along with the definition of employer would come the concept of the FLISA concept of employment. That seems like necessarily how you'd interpret the statute. And the sufferer permit test has already sort of part of Colorado wage and hour law. I'll say that I didn't anticipate all of the work that the Trump administration would try to do to disentangle the concept of joint employment, the employer definition from 203D from the rest of the statute and the really broad definition of employment that's sort of core to federal law. So hopefully we never have to confront that issue, and are optimistic too about the possibility of state level rulemaking in Colorado and hopefully elsewhere. Thanks, Matt.
Thank you, David. Any other questions, Mark?
Yeah.
Matt?
Yeah, I have a question for Ali. I've always been interested and intrigued by the power design case. It is far more common that tradespeople in the basic trades are subject to misclassification and cash labor brokers and cash compensation. It's less true of some of the licensed trades like electrical work. So I'm curious as to what your experience. I'm not aware of any other cases of that magnitude involving electrical work. Was this unusual, or what was your experience with that?
So this was our biggest settlement to date, was in the electrical industry. But what we've seen in a number of our investigations is that the drywall industry and the electrical industry are some of the largest industries that are violating trades that are violating district law.
Yeah, I mean, drywall is certainly apparent all over the country, but it's been less publicized about electrical work. So that was it. That was an interesting development.
Yeah, it definitely was. And it because of the expansive scope of that investigation, we now are looking very closely into the electrical contracting industry, and we are finding additional violations.
Interesting.
I would like to ask Ali, given the vigor of the new statutes in DC and their prosecution, have you been getting contacted by other states? Or not that you're a state yet, but no,
perhaps, I like it. I like it.
Yeah, thank you. That's my little humor. Have you been getting contacted by states about how it's working out and getting inquiries about how they might themselves emulate the initiatives you've taken in DC?
Yes, thankfully we have a really great and network of states. We have a multi-state coalition, that David was talking about in that with the FLISA lawsuit, that we work together very closely. And Terry Gerstein, and who I know Mark works with, has really helped sort of foster that effort of the multi-state collaboration. And so we exchange ideas and how to best, implement and enforce these laws on a regular basis.
So you're optimistic this might be extended to some of the states like Georgia and Florida?
My personal opinion is that misclassification is really the issue of our time. It's really what is harming workers. It's how businesses are operating. They're cutting their labor costs to make for higher profits at the expense of workers. And I really think that that's like the bottom line problem of what's going on in the labor market and in their economy right now. And so, yes, I do think I am optimistic that the law will catch up to the way that businesses are operating.
Well, we have about 2 minutes left. Any other questions from the panelists for each other?
I'll just interject because I think it's a resource that just occurred to me that I think folks should check out. Ali mentioned, and I'm sure many of the folks on the call know or have worked with or have heard of Terry Gerstein, a fantastic lawyer and advocate. She just recently wrote, I think, which is just a great op-ed on workplace phishing involving a wage theft case against Kim Kardashian in California. And I thought it was really wonderful. I think phishing, along with misclassification, Ali, is some of the most pressing issues in our economy right now. And Terry did a fantastic job of presenting it in terms that don't make your eyes glaze over, as I tend to make people's eyes do when I talk about phishing.
Well, we're in the era of people celebrating the gig economy, and books have been written about it here in Nashville in the music business, and so I think that we're in a moment in time when there's a lot of confusion in the general public about the kinds of practices that we're discussing here and what's seen as the celebration of individual entrepreneurship. And in the gig economy as an image for the future, without much understanding or consideration of the forms of exploitation that are being discussed and that are sometimes supported institutionally by some of the major players. Well, we are at 11:45. And that's our time to sign off, or 12:45, I guess, on the East Coast. So thank you all. I think that we had a wonderful contribution to the conference and to all of those who signed on for this session. Thank you for being here. I'm very grateful to everybody. All right, I'm going to stop recording now. And